So I was asked to speak on the Ambedkar's vision and the constitutional challenges in the contemporary India. Before I really delve into the various aspects of that in the limited time which I was given, so let me first question the very notion about Ambedkar. The moment we say Ambedkar, there is unwanted, undesirable antipathy towards that great legendary son of Mother India. The reason for that is Ambedkar was a champion of the downtrodden. Ambedkar was a champion of the socially and economically marginalized people of this country. So the forces which are opposed to the transformation of society obviously take a hostile stand towards Ambedkar. But they should also know that Ambedkar is certainly the legendary, Ambedkar is certainly the champion of the marginalized, but he doesn't represent any particular caste. So I just quote one statement of Dr. B.R. Ambedkar. He said, the progress of a nation, the progress of a society is measured by the extent of progress the women of that society have achieved. This is what he said. When he said women, he did not mean Dalit women. He also included Brahmin women in that. So that is Ambedkar is the champion of all oppressed castes, classes, communities, nationalities, linguists. Every group of society which is oppressed should find in Ambedkar a legend who always articulated the cause. So when we talk about Ambedkar's vision, it is essentially the preamble of the Constitution reflects the vision of this great man. Today the challenge to the preamble is so pronounced. Today morning you might have seen in the newspapers, a person no less than the Vice President of India says, I do not agree with the Keshavananda Bharati verdict. I'm sure you as a students of law, you might have read in the today's papers. I have no objection if somebody disagrees with the court judgment. Well, anybody can disagree. Just honorable judge is here who has immense contribution to the world of law. So as a citizen of India, we also feel judiciary should not be invincible to criticism. Only the problem comes when you attribute motives to the judges. As long as you don't attribute motives, you have every right to differ with the verdicts of the highest courts of India. So I have no objection when the Vice President disagrees with the 1973 landmark Supreme Court judgment in the Keshavananda Bharati case. But the problem comes only when he tries to obliterate the verdict. That's the problem for me. I have no problem as long as he disagrees. I have no problem as long as he differs with the Supreme Court verdict. But the problem comes when the politics of the day tries to obliterate the very spirit of the Keshavananda Bharati case. So what did Supreme Court say in the Keshavananda Bharati? Today the Vice President talks about the parliamentary sovereignty and parliamentary autonomy to attack judiciary. He questions the separation of powers, the cardinal principle of the Constitution of India, to defend his argument and attack on judiciary. And surprisingly, the lapses in the judiciary are even taken to the advantage. Well, I don't say that judiciary was all perfect. So it's true the government of India in a presentation to the Union Law Ministry has been telling this. I'll come back to that. But my question is, did Keshavananda Bharati verdict question the parliamentary sovereignty and autonomy? As the Vice President of India was also a liar, wants the nation to believe. The problem here is we are living in a post-truth age where it is extremely difficult to distinguish between truth and falsehood. So what did, as students of law, you know much better than me, the Supreme Court has only said Parliament has the power to amend the Constitution of India, but it cannot amend the basic structure of the Constitution. So basic structure reflects the preamble of the Constitution, and thereby it reflects the vision of Dr. B.R. Ambedkar. So the preamble includes liberty of thought, the preamble includes fundamental rights, the preamble includes the freedom, the preamble includes secularism, federalism, democracy, separation of powers. These are the principles in the preamble. So what does the Vice President say? Vice President says that the Supreme Court of India, through the Keshavananda Bharati verdict, has eroded the parliamentary sovereignty and autonomy. But in fact, in the Keshavananda Bharati verdict, the Supreme Court upheld the constitutional sovereignty and a constitutional supremacy. So today the ruling dispensation wants to replace constitutional supremacy with executive supremacy, constitutional supremacy with the legislative supremacy. But what is the spirit of upholding the constitutional sovereignty? An executive or legislature can be an instrument of tyranny at times. It is not always possible that the people's verdict will be a wise and generous verdict. Assuming that today, if the parliament tomorrow makes a law that Hindi should be mandatory in every part of the country, only Hindi should be spoken and Hindi should be taught in Telangana, Andhra Pradesh, Tamil Nadu, wherever it is. Just because the parliament made the law, should the nation follow it? Well, parliament can certainly make this law. Because if the majority accepts it, it can become a law. And today the Hindi speaking people and those who may not have the Hindi as mother tongue but still love Hindi, then that makes up to the majority. Because in Lok Sabha, 130 come from South India. So what is 130? UP 80 plus Bihar 40, 120. So just because you have the tyranny of majority, can you impose the linguistic chauvinism on us? Tomorrow, assuming that parliament makes a law that only Hindus have a right to vote but not Muslims, or but not Christians, but not tribals, but not Dalits, should we accept it in the name of parliamentary sovereignty? Tomorrow, if the parliament says, we will not have any state assemblies, we will not have any state governments, there will only be the union government. Union government appoints governor. Governors are anyhow functioning like chief ministers today in some states. So we will make it legally also. Only governor appointed by the government of India will rule the state. Should we accept just because the parliament has made that law? Justice V.R. Krishna Iyer in an epoch verdict said, what is legal need not be justifiable also. That's the reason we call Union Ministry of Law and Justice. As a young student, I really got a doubt. Why should it be called law and justice when law is equivalent to justice? There should only be law. So it should only be Union Ministry of Law. In fact, the College of Law should be renamed as College of Law and Justice. Because there cannot be law without justice. So the reason why the Union Ministry of Law and Justice, precisely because law may be in support of justice. Sometimes law may violate justice also. That's the reason V.R. Krishna Iyer said, what is legal may not be justifiable. So what should we, as a citizen of India, we have to uphold justice, not the law. Tomorrow law is against justice. As a responsible citizen of this country, I would take pride in violating the law. I would certainly take the pride in violating the law. When much before the Supreme Court struck down the Section 66A of IT Act, you still remember two women in Maharashtra who do not know anything about law or constitution. They run a beauty parlor. When somebody declared Bandh, I think Shiva Sena declared Bandh, They were worried about losing their livelihood and said, why should there be Bandh? So for that, they said this in a Facebook post, not anywhere else. And they were arrested under section 66A of IT Act, if I remember properly. And I have, as a legislator, I staged a dharna at Indira Park, stating or keeping some paper on my chest, I will violate this law, let police arrest me. I said, I will violate this law. I will violate this law because it is the duty of because I believe in the Constitution of India, for which Dr. B.R. Ambedkar was the architect. So therefore, my point here is, just because Parliament makes a law, just because the parliamentary sovereignty and autonomy has to be upheld, then what happens to the constitutional sovereignty? There will be tyranny of majority in Parliament. Democracy need not always be good. There can be tyranny of majority also. So that is the vision of the Supreme Court of India in the Keshavananda Bharati verdict. But a person who is the Vice President of India says, I do not agree with the Keshavananda Bharati verdict. It really means I will obliterate the Keshavananda Bharati verdict precisely because it erodes the parliamentary sovereignty. I strongly feel that for me, not the parliament is sovereign, for me the constitution is sovereign. Because, why it is? Because the constitution begins with the magic words, we the people of India. Constitution of India is not the gift of any royal prince. Constitution is not the gift of any priest. Constitution is the gift of the people to the people of India. So therefore, constitutional sovereignty, the real embodiment of people's sovereignty, but not the parliamentary sovereignty. This is something which we have to tell the Vice President of India, unfortunately, who was also a Supreme Court lawyer. Then the Union Law Minister openly says, we will appoint judges. He has openly, publicly demanded that the power to transfer, appoint judges should be with us. Well, for that, he quotes the social composition of judges. I totally agree with the law minister that such a truncated social composition of judiciary is absolutely unacceptable. So 79% of judges appointed to the high courts in the last 5 years belong to the upper caste and 11% belong to the backward classes. 2.8% belong to minorities, 2.6%. 2.8% belong to scheduled caste. 1.3% belong to the scheduled tribes. So backward classes, as per the Mandal Commission, account for over 50% of the population. And I am not advocating reservations in judiciary, but my argument is whether there are reservations or not, there should be an affirmative action so that the judiciary reflects the society of India. So what does the preamble of the Constitution says? The preamble says equality, social and economic. Unfortunately, the composition of judiciary, which is supposed to uphold the Constitution of India, doesn't reflect the preamble of the Constitution. It is rather surprising when the highest judiciary of India does not represent the preamble of the Constitution, which envisages social equality. Then where can we achieve social equality? I agree with the law minister to this extent. But why is law minister quoting these figures? He is not quoting these figures from a point of view of social justice. He is quoting these figures to attack the collegium system. He is quoting these figures to demand that the government should have the power to appoint judges. Well, I am not a supporter of the collegium system. I have an equally differing opinion on that. But collegium system cannot be replaced by government control over appointment of judge and transfer of judges. So there should be a broad-based procedure for that. But today the government of India openly demands through the Union Law Minister that we want to appoint judges. Is this not against the separation of powers? Is this not against the Keshavananda Bharati verdict which declared separation of powers as part of the basic structure which is inviolable. Precisely that is the reason Vice President comes to the fore and says, I will not even agree with the Keshavananda Bharati verdict. So therefore the first attack is today on the separation of powers. Second, the Union Home Minister, not the present Home Minister, Rajnath Singh, told in Parliament that secularism is a postscript to the Constitution. Secularism is added to the 42nd Constitutional Amendment brought about during the dark days of emergency. Therefore, secularism is not integral to the Constitution of India. Unfortunately, there is also a political propaganda to state that the Dr. B.R. Ambedkar also did not want India to be secular. There can nothing be more farcical than this. In fact, as students of law, you know very well, there was a debate in the Constituent Assembly. What was the debate? How should we begin the Constitution of India? So there was a demand to start the Constitution of India in the name of God. And the Constituent Assembly debated it and finally voted on it. The majority said we can't start the Constitution in the name of God because it is sectarian. So that is how the Constitution began with the words, we the people of India. So can there be anything more secular than this? Then what did Ambedkar say? Ambedkar only said when the question came on the issue of word secular being part of the constitutional draft, Ambedkar said, it is superfluous, therefore it is obvious, he said. It is obvious, therefore it is superfluous. What is the meaning of it? So it is obvious. We don't say Hyderabad is the capital of Telangana every day. Do we say that? Because it is obvious that Hyderabad is the capital of Telangana. Do we say that the Usmania University, which is located in Hyderabad city, which is the capital of Telangana, which is a state in India, do we say that? We don't say that because it is obvious. We don't say because stating obvious is superfluous. That is what Dr. Ambedkar said. Ambedkar did not say that India should not be secular. Unfortunately, Ambedkar's words are distorted. But does the Home Minister of this country not know the Supreme Court verdict in S.R. Bommai case? And a Home Minister states in the Parliament, which is contrary to the S.R. Bommai verdict. And as far as I understand, distorted interpretation of the court verdicts tantamount to contempt of court. So the Union Home Minister actually violates not only it should attract not only the privilege motion, but should attract contempt of court. Because Supreme Court in so clear terms said in S.R. Bommai case, what was implicit in the Indian Constitution was made explicit by the 42nd Constitutional Amendment. This is what the Supreme Court said. So I quote again, what has been implicit in the Indian Constitution is made explicit by the 42nd Constitutional Amendment. So the meaning of it is, Constitution of India was always secular. Only thing is the word secular was added through the 42nd Constitutional Amendment. It is factually true, but that doesn't mean India was not a secular constitution when it was drafted. And the Supreme Court of India in the Keshavananda Bharati verdict itself said that the secularism formed part of the basic structure of the constitution. If secularism is not part of the Indian constitution, why will Supreme Court say it formed part of the basic structure of the constitution? I really don't understand. But the Home Minister argues on the floor of the House, contrary to the Supreme Court verdicts, contrary to the highest court verdicts. So this is an attack on secularism. Then the third is the federalism. Why should India be federal? India should be federal because that is the idea of India. India is a combination of several language groups, several religions, customs, traditions, and India is a diverse country. We take pride in unity in diversity. So how can a diverse country be unitary? That is a fundamental principle. I agree with the fact that the Indian Constitution has several unitary features. But that was the context in which the Constitution was drafted. So any document of literature will always reflect the situation and the times in which that literature is drafted. You cannot expect a book written 100 years ago to talk about internet or chat GPT or open AI or artificial intelligence. Is it possible? Did Gurujara Appara in Kanyashulkan talk about artificial intelligence? Did Gurujara Appara talk about chat GPT? That doesn't mean Gurujara Appara is a fool. Because he will only reflect that particular times. So the context in which the constitution was drafted, we all know. 500 principalities refused to accede to the Indian Union. There was a communal carnage. There was a partition of India. So the vociferous forces were on the rise, and the founding fathers of the Indian Constitution were worried more about the unity, integrity, and sovereignty of the country. That was the reason why India is called Indian Constitution has several unitary features. But what did Ambedkar say? Ambedkar very clearly said, Indian Constitution is a unitary constitution in emergency circumstances and a federal constitution in normal circumstances. This is what Ambedkar said. So on Article 356, Ambedkar said, I hope it will be a dead article. Unfortunately, it was the most living and kicking article until the S.R. Bombay verdict has come. So it is the political culture that destroyed federalism, but not the Constitution of India. We should have strengthened the federal features of the Indian Constitution as the context changed. But instead of strengthening the federal features, we are continuously weakening the federal character of Indian Constitution. Agriculture forms part of the state list, but the Parliament makes the controversial farm laws. Education is part of the concurrent list, and the Supreme Court in a case very clearly said that even if it is in the concurrent list, that does not automatically mean state legislation enacted by the state assembly will automatically disappear. It's not true. The spirit of the concurrent list is, to the extent possible, the central and the state legislation should coexist. Only if it is unavoidable, central legislation prevails over the state legislation. That is the federal spirit of the Constitution. We call union of states. That doesn't mean India is not federal. Supreme Court very clearly said, why is India a federal constitution? Talks about union of states. It says union of states because Indian Union, unlike the other nations, is not a result of a prior agreement between the states. So that is the reason why. So it very clearly said, India is an indestructible union, it is a destructible union of indestructible states. This is what the Supreme Court said. It is the destructible union of an destructible union, it is the indestructible union of destructible states. I'm sorry. So the union is indestructible, but states can be divided. So that was the reason why I said. But today cooperation, union government intervenes. Several areas which are essentially either to domain of state are now taken over by the government. Power is a concurrent list, but the government of India imposes central power legislation. Look at the governors. Before I conclude, I have already spoken for a long time. So governors, it is obnoxious that the governors act as if they are the chief ministers. We don't elect a governor. Surprisingly, the governor of Tamil Nadu refuses to utter the names of the Tamil icons like Annadurai, like Periyar, like Karunanidhi, and his contempt for even talking about Ambedkar. So the Tamil Nadu governor takes oath in the name of Constitution of India, but he refuses to utter the word Ambedkar in the speech, which is present in the written speech. He refuses to use the word Dravidian model. And Supreme Court in Arunachal Pradesh case, in several cases, in Shamsher Singh case, in many judgments have clearly said, in fact Ambedkar said, when there was a question about the functions of governor in Constant Assembly debate, Ambedkar said, what is to they talk about function, because governor has no functions at all, he said. When governor has no functions, where is the question of defining the functions of the governor? So governor acts on the aid and advice of the Council of Ministers headed by the Chief Minister. But the governor of Kerala says, I am withdrawing pleasure from the finance minister, as if it is a personal pleasure. Well, Arif Muhammad Khan can eat ukma or dosha, that is his pleasure. But can he withdraw the pleasure from a minister? The Chief Minister said, I have the pleasure, so keep quiet. So the governor of Tamil Nadu refuses to read out certain portions. Well, he refuses to respect even national anthem. That is surprising. He leaves the house before even national anthem was concluded. And governor of Telangana says, what would have happened if I have not signed on the file to summon the state assembly? Does the governor have the power to do so? When the Arunachal Pradesh governor advanced the assembly session, Supreme Court very clearly said, the power to convene the assembly is not with the governor. He cannot act independent of the advice of the Council of Ministers. This is what the Supreme Court said. But unfortunately, governor says, what would have happened if I had not signed on the file? Because there is a constitutional principle that the interim period between the two sessions of legislature should not exceed 6 months. So the governor says, if I have not signed on the file, the 6 months would have elapsed. But the governor doesn't have that kind of a power at all. And this is the situation which we are living in. So there is an attack on secularism, there is an attack on federalism, there is an attack on the basic structure, there is an attack on the separation of powers. So as a students of law, my appeal to you is, let's take a oath in honor of Dr. B.R. Ambedkar that we would steadfastly defend the constitutional values. So to make this country a great nation, India has not slided into anarchy. India has not slided into despotism. India has not slided into theocracy. India has not slided into constitutional chaos, because we have a very great constitution. The average age of a constitution in the world, if you calculate the life period of all the constitutions of the world in the last 150 years, the average period of the life period of the constitution was 17 years in the world. But Indian constitution endured for more than 7 decades. That is the true honor to the vision of Dr. B.R. Ambedkar. So we are deeply, as a nation, we are indebted to this legendary, and I once again appeal to you to defend the constitutional values of democracy, liberty, secularism, federalism. We have a law of sedition which says, even if you utter any word, you can be booked under Rajiv Sardesai tweeted. For the tweet, he has to face a sedition case. Way back in 1962, Supreme Court said, there should be a link between the act and the violence. When there is no link between spark and the powder cake, this is a theory the Supreme Court said. So there should be a spark and a powder cake relationship. Otherwise, it doesn't amount to sedition. But today, even when there is no powder cake, no spark, people are booked for expressing their freedom to express, for implementing, for utilizing the constitutional right to speak. Then people are booked under law of sedition. So we need to rededicate ourselves to a sacred battle to preserve the Constitution of India. Thank you very much for a patient hearing.